I'm Debbie Moraes. Welcome to Legal Matters, the program that's designed to address some controversial, timely issues that we've been covering lately, a wide variety of topics that affect the lives of consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of issues, and we're glad that you're with us. We've talked about business startups and a lot of topics that really affect the business and consumer's pocketbook lately, and most recently we were discussing traffic violations in the municipal court. There were so many questions, there were things that weren't covered last segment, so we decided that we would pick up where we left off last segment. And with us this week, and she was not with us last week, is Jackie Grasso and, once again, David Bizarre from Audette Bizarre Cordero Grasso Law Firm in East Providence. We did have a couple of questions, so we're going to get right to them. While we were talking about traffic violations, routine speeding tickets are often paid off and assume that would give you the least possible amount of consequences. However, someone wrote that there is an exception to the rule if you pay the fine in conjunction with going to traffic school. So completion of traffic school normally means that that ticket won't appear on your record if you've taken classes. Is that true, and who should care about that?
Well, it depends exactly on what the judge wrote in the order when the case was decided. What you read the question to be was they paid a fine and the judge ordered them to go to driver's retraining school. Under those circumstances, it would seem to me that that driver's retraining was a secondary penalty that the judge added on.
Exactly, yeah.
So therefore, there will be a conviction on your record for that if you paid a fine for the ticket.
Now, if they merely pay the court cost and the judge orders the individual to go to traffic school, it could be that the traffic school is in lieu of the penalty
Right.
imposed on the ticket and an actual guilty conviction.
Right.
So it could be subject to dismissal based upon completion of a traffic school.
And the Rhode Island Traffic Tribunal magistrate or the municipal court judge will say to the person as they're going through it, the penalty is this, and at the end of my sentence, if you complete driver's retraining or if it's community service or whatever penalty is given, the ticket will then be dismissed. Then the ticket will then be dismissed. But the judge won't fine you the ticket and then dismiss the ticket.
Yeah.
Okay.
You have to really look at the notes. I put notes in the file, in the folder that we get with the ticket. So again, what David said is you have to look at what the judge wrote as part of the order.
Would it be safe to assume that only a first offender might get a little slack, or how does that work? Is there a good driving statute that says, I've only done one bad thing, here's my one and only ticket, please dismiss it, or can I just...
Rhode Island does have a good driver statute. Essentially what it says is if you have not received any moving violations in the last 3 years, 3 years prior to the date you received your ticket, then you can invoke that statute, ask the court for a dismissal. However, you cannot have been driving more than 10 miles an hour? More than 10?
That's right.
Yeah.
And there's certain other offenses that are included in
That's
there
right.
that wouldn't be dismissed. If you go by a school bus, for example.
Exactly.
If
Very
there's
different.
an accident, you can't use the good driving statute.
If you have a CDL, which is a commercial
CDL.
driver's license.
And that's under federal law. The
Yeah.
federal government threatens to take away funding for state highways if you mask a dismissal of a ticket by using a good driving record, for instance. So CDL, commercial driver's license, aren't subject to being using the good driving statute.
Massachusetts does not have a good driver's statute, so if you want
Good
to
to
fight a
know.
ticket, you do have to appeal it, or actually you have to appear in court. More than likely, it's your district court. The other important part of the good driving statute is even though the case will be dismissed, provided they qualify under the statute, the law requires the individual to plead guilty. So that means they're giving up a right to a trial, which we as municipal court judges have to inform them that even though you're pleading guilty to, you realize you're giving up your right to a trial, which means you have the right to examine witnesses, cross-examine witnesses, and appeal this ruling to a higher court. That has to be what's called a voluntary plea.
Right. You go through the whole constitutional rights that a
Exactly.
person has before they enter that plea. The rights that Jackie just mentioned, the right to present your own testimony, the right to appeal, as Jackie said, any finding of guilt that a judge may give. And we also tell them that they can't use the good driving statute again for 3 years.
Right, yeah.
So
That's right.
if you have a defense and you want to raise it at that trial, you can do that. Now, Jackie raises an interesting question with me on this issue, is if someone asks for a trial, and then they are going to be found guilty after the trial, can they then say to the judge, wait a minute, you know what, I'll just use my good driving record?
Yeah, that happened to me. I had a trial
that
about, I honestly, I looked at the woman, I said, you know something, I'm going to have to get back to you on that, because every so often, a unique issue will pop up. And I read the statute again very closely. It's a little convoluted in the way
Right.
you read it, but yes, you can. The answer is yes, you can.
That, we read it together. That's our reading. It appears to us that in
That's
the,
good to know.
Yeah, if the sentence hasn't been imposed,
That's exactly right.
Prior to the
prior
sentence.
to
Okay.
your
right.
saying that you want to withdraw your not guilty plea and enter a guilty plea on the good driving statute, that the judge has discretion at least, although the good driving statute doesn't seem to have a lot of discretion in it. It almost says the judge shall.
Exactly,
Yeah.
Plus,
which-
we don't have any discretion with court costs, so it's a
Well,
mandatory
yeah,
$35 fee.
There's an administrative fee, they call it, which is non-waivable
Yeah.
by the judge.
Really?
And we
Okay.
have no discretion with that.
I do have another question, but let me follow up with what we were speaking of here. What happens if someone wants to appeal?
Okay?
What happens
After a
then?
trial?
Yes.
So they've had their trial, they've put their evidence on,
In
they've
municipal court.
In
cross-examined
municipal
the other.
court.
Then they have within 10 days to file a notice of appeal, which would go to on a moving violation, a traffic violation, to the Rhode Island Traffic Tribunal appellate or panel, an appeals panel that's set up of 3 judges who will have to look at the transcript from the case. So part of the duty of the motorist is to file the appeal. Is it $25?
$25 fee.
And then also order the transcript, which every municipal court has a recording device, so there's a recording of it. They're supposed to get that transcript.
From a clerk?
They go to the clerk and they ask for the recording, and then they're supposed to take it to a stenographer and have it turned into a transcript.
Which you have, the onus is on that
The
person
motorist.
to pay for that transcription,
That's
okay?
right.
Yeah. And if you do not prevail in traffic tribunal, you have the right to appeal to the 6th Division District Court within 10 days from the date of that decision.
So you have 3
Again,
options to appeal,
Yeah.
or 2
well,
options of.
you have
Right.
2, but then ultimately, if you don't prevail in district court, you can go to the state Supreme Court.
Right. And interestingly
A
enough.
bit more expensive.
Yeah.
Yeah.
And back in the day, before the traffic tribunal, before municipal courts had a wide jurisdiction over moving violations, back when moving violations were a misdemeanor, which I don't know if they are in Mass, but the trials were in Superior Court. And there were a lot of appeals by a particular lawyer to the Supreme Court, challenging all sorts of issues in Rhode Island on prima facie evidence of speed, reasonable and prudent speed, and all of those different types of issues that come up in speeding tickets. I don't think the Supreme Court gets a lot of speeding tickets anymore.
No, and we're fortunate because we do have cases that we can often refer to,
Right.
thanks to that particular attorney. He litigated nothing but traffic cases.
It's-
at
or
one
so
point.
it seemed. I
Or
don't
so
think he
it
had
seemed.
time for anything
Yeah,
else.
Yeah,
So fewer are being appealed up to those higher level courts.
very rarely.
Right. You know what you'll see
Words
now,
realized.
which is
Yeah.
more akin to what was happening with speeding tickets back in the 60s and 70s, which
Mm-hmm.
is when these took place, are the appeals on the DUI and
Yeah.
refusal cases.
Yes.
And we, as municipal court judge, do not have jurisdiction
No.
on those. Those go directly to the traffic tribunal.
For
And tell her what a
refusal.
refusal is. Yeah.
Refusal is the person who is driving and is pulled over on suspicion of driving under the influence, is asked to take a chemical or blood test, and if they refuse that, then that's a separate charge from the actual charge of driving under the influence. Traffic tribunal, refusal, district court for the DUI.
And last week when we touched upon that, we
Yeah.
didn't address it in Massachusetts.
If
What
there's a
happens if you
refusal in
refuse?
Mass, it's automatic loss of license. 6 months.
to
Automatic,
know.
and if you want to appeal that, you do, I believe, have to go to the Registry of Motor Vehicles in Boston or
Okay.
wherever,
Yeah.
what region it is.
And-
It's an
and in
automatic loss of license.
Rhode Island now, the refusal is 6 months as well.
They changed,
Right.
yeah, okay.
Well, not entirely unrelated, but a very timely topic. It's another question that came. At prom time, 16 and 18-year-old teenagers paired up, went on a party bus. They weren't driving, but they were drinking. It's a private bus. They get pulled over, they're arrested. This is because they're underage drinking, but not driving. So it's not